You're watching the Bloomberg Law Bankruptcy Review. I'm Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column, available on BloombergLaw.com. It's also on the Bloomberg Terminal. We're talking about the Madoff case today. It's been a while since we've touched base on it, but it looks like Judge Jed Rakoff has a major opinion out. It's good for Trustee Irving Picard, bad for customers. Is that the takeaway? Did I get that right?
Got it right dead on. Poor old Irving Picard, the trustee, he'd been having the stuffing kicked out of him every time he went before District Judge Jed Rakoff, who has taken away most of the important business in that case from the bankruptcy judge, until this opinion by Rakoff on the 30th of April. The decision he made goes really to the core of the case in terms of the liability of customers of Madoff, who were among the lucky ones who managed to take out more cash than they put in. Mm-hmm. These people are known as net winners because they took out what I guess you could call fictitious profits, which in reality, according to the trustee, was actually money stolen from other customers because Bernie Madoff never purchased a single share of stock with the billions that the customers gave him. In any event, the traditional fraudulent transfer law had said that the fictitious profits you get out of a Ponzi scheme are proceeds of a fraudulent transfer, and you got to give it back, no ifs, ands, ors, or buts. Now, there was so much money, and is so much money involved in the Madoff case, that the customers who were being sued for billions started coming up with theories that ranged from the logical to the creative, to the flaky or the fictitious. And they presented these arguments to District Judge Rakoff, and basically he didn't buy any of them. And this decision, therefore, is a bad result for the customers. It's bad in the sense that Rakoff held that they got to give back the fictitious profits that they received within 2 years of bankruptcy. It's good for the customers because at the same time, Rakoff held that the trustee cannot sue going back 6 years.
Right. Could have been worse.
Oh, it could have been a lot worse. And frankly, when all is said and done, and when we have some judgments that go up on appeal, Trustee Picard is going to be asking the Court of Appeals to say, yes, sirree, you can go back 6 years, not just 2. Because in my own view, I think the limitation of 2 years that Rakoff put on these claims is debatable at best, and the result could go the other way. So I suppose the customers ought to be thankful that their liability is only 2 years. It's going to be a while yet before it winds its way through the court, where these customers actually have got a judgment against them. But that's the way it's pointed right now.
At least we have some clarity, something of a pacing rabbit in this 2 years benchmark that's been put out there. Bill, I wanted to ask you about another issue in the Madoff case. Earlier this week, Twitter was abuzz over the notion that Trustee Irving Picard has collected more in fees for his engagement than he has distributed to customers. What do you make of that? Well,
it is statistically accurate, but qualitatively off the wall. And here's the reason why. True, the trustee has distributed about $325 million, and the cost of the case so far, at least in terms of attorney's fees, is more than $500 million. But the reason he hasn't distributed more, it ain't a bit his fault. It's because customers are appealing everything he does.
And there's a lot of customers out there, a lot of balls moving around.
And until all of these appeals are decided, he can't distribute more. Now, in the trustee's favor, the fact of business is that Trustee Picard and his lawyers have either collected or will collect or have money in the bank, essentially, amounting to between 11 and 12 billion dollars, not million, but billion. And customers' claims are somewhere in the neighborhood $17 billion. So he already has essentially, except for the appeals that are outstanding, collected a huge portion of customers' losses. And as I said, it's not his fault he can't blow all that $12 billion out. It's because of customers taking appeals, especially it's the customers we just talked about, the ones who are the net winners that are going to be facing lawsuits to give back at least 2 years of profits.
Tough case. It's a big one, and it sure is complicated. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the case or issues we just discussed, be sure to check out our offerings on BloombergLaw.com. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Pacchia. Thanks for watching.